Okay, good morning, everybody. It's 11 o'clock, 1 minute past 11. Let's get started on today's webinar. And we are going to be talking with Chuck Krugel, who is an employment law attorney who practices on behalf of management. Chuck has a bachelor's in psychology from Bradley University and a master's in psychology from the University of North Carolina at Charlotte. And of course, he has got his JD from Ohio Northern University. Chuck is very involved with a lot of civic organizations and is always looking for ways to give back. He is a chair and member of the board of directors of the Oak Lydon Developmental Services, which was founded in 1956 to service the Oak Park and Lydon Township communities in suburban Chicago, with people with developmental disabilities learn the skills needed to live an independent life. Chuck is also the vice chair and member of the board of directors for the Lakeside Community Committee, which is a 45-year-old child and family advocacy, housing, and adoption agency. Chuck is also a member of the board of directors for the Youth Outreach Services, a 50-plus-year-old teen advocacy, housing, and direct service organization in Chicago. He is a member of the board of directors for the Kelly Hall YMCA in West Humboldt Park, of the part of the Chicago YMCAs, and a member of the board of directors for Latinos Progresando, which is a 30-plus-year-old immigration advocacy and legal services agency. Is a member of the board of directors for the Decalogue Society of Lawyers, which for over 80 years, the Decalogue Society has supported Jewish lawyers and the legal community in Chicago and throughout Illinois. Chuck is also a member of the board of directors for the Mental Health Association of Greater Chicago. He's a member of the advocacy committee for the Chicago Bar Foundation, and lifelong Chicagoan, and we are really lucky to have Chuck. And with that, Chuck, welcome to the webinar today, and I think we need more light on your face.
Thanks for having me, Mohammed. It's always been a problem with this, I guess because of the background.
Yep, you got a wonderful view in the background over there. But let's dive right into some of the issues that we want to discuss today,
Sure.
Chuck. And one of the things that I wanted to start off with, especially in the immigrant community, who, when they come over and they start businesses over here, most of us are not really aware of all the, the nooks and the crannies of employment law, especially. And if we can get into that as we go along today, I wanted to start off with some of the new laws and requirements that have come in, especially as a result of the pandemic and the PUDA things and stuff that is going on. You want to give us a little heads up on what is happening with some of the new laws that employers need to be aware of?
Yeah, so you have I think the key one is the Family First Coronavirus Response Act, Family First Coronavirus, FFCRA or something like that. It's a long acronym, but anyway, it's part of the, it's all entailed or kind of jumbled up with the PPE, Payroll Protection Act stuff and all that. So basically, this is all going to be in effect till the end of the year, December 31st, 2020.
Okay, so that kind of started on, I believe, the 27th of March, right?
March, yeah.
Yeah.
And they just started, well, it went into effect the 27th. I don't think they started enforcing it until maybe in April or so. And actually, I'm not even sure what kind of enforcement they're even doing if they are even doing enforcement. That's just the guidance that they issued, was that the government, the CDC and these other agencies, Department of Labor, said they weren't going to start enforcing it until a few weeks after it went into effect. So, it's hard to say where they're at with that.
And it also, I believe, expanded the FMLA, right?
Well, yeah, that was one of the key things with the Family First Coronavirus Response Act, was expanding unpaid leave under Family Medical Leave Act into now paid leave. And depending on what level the employee's at, or where the employer's at, it could be anywhere from like about maybe half of the pay, regular pay, to about 100% regular pay. It could be sometimes pay time off, not pay time off. And this is all into effect until the end of the year. but it also it directly relates to coronavirus issues or COVID-19 issues. So if the employee is not claiming they have COVID-19 related issues, then the Family First Coronavirus Response Act does not apply to that situation. And as an employer, you are entitled to ask for documentation from some sort of medical provider about that. So, I mean, obviously it doesn't include like a voodoo doctor, but it can be like a
Okay.
nurse or or some sort of physician assistant or something like that, not necessarily a physician or a doctor.
Okay. So let's let's be clear on this. I mean, so this FFCRA does not apply to all employers, right? I mean, if you have less than 500 employees, what happens?
Yeah, if you're less than 500 employees, it applies to you. It
Okay.
doesn't apply to more than 500, but there are hardship exceptions for I think fewer than 50 employees or so. But there are and there's hardship exceptions in general where you would have to provide your tax statements or bank financial statements and basically show that um, with the Family First responsibilities, coronavirus related responsibilities, you would go out of business or be significantly hindered from operating.
Okay. So if an employee takes off because of the COVID-19, and the employee has to bring in some documentation that they were either impacted or where you know uh, there were chances of them being impacted, and how does that work?
Well, first of all, it's not necessarily that they have to bring in the documentation.
Okay.
If they're asked by their employer, then they have to provide it. So, and then employers are basically required to engage in what's called an interactive discussion, like a sort of a one-on-one or small group discussion with that employee to find out what their situation is and whether or not any of their health issues can be reasonably accommodated under Americans with Disabilities Act or the state or local equivalents.
Okay. Talk to me a little bit when you say that Americans with the Disability Act. Talk to me a little bit about the EEOC issued guidance on this.
Yeah, I mean, the EEOC issued guidance is nothing spectacular on this. It's frankly, I think the best government guidance, by the way, has been put out by the U.S. Department of Labor. They've been really
Okay.
cool. They've been really good. The EEOC guidance is nothing special. They're dealing largely with what's called protected class issues. The legalese is like disparate impact or disparate treatment. So basically, what they're dealing with is issues that would disproportionately impact against a protected class. So it could be like on basis of religion, like Muslim or Judaism. It could be on the basis of national origin, ethnicity, Hispanic, Black, that type, any sort of protected class. So they're trying to make sure that any testing, any temperature taking, any sort of reporting or data gathering doesn't disproportionately impact against a protected class.
Okay.
And that you're not paying less to protected classes than you would what's commonly known as like the white male majority.
Okay, let's take a step back and look at again from an employer's perspective now. The documentation that employers get in this. I know that, for example, with the W-9 information and all of that, that is supposed to be kept in a separate, secure filing system that is protected and all that. How does that impact all of these new documentation that employers are requiring because of this COVID-19?
Well, general medical records should always be kept separate from general employee files.
Okay.
I mean, medical records regarding specific medical conditions, obviously like open enrollment election forms or things like that can be part of the file, but anything regarding specific conditions and the employee's specific disabilities or whatever accommodations they need should be kept, anything medical should be kept separate under lock and key and all that.
Okay.
Also, by the way, just you mentioned something, Cause you mentioned W-9. The Family First Coronavirus Response Act also does apply to independent contractors.
Okay.
So that's something much different than what we've been used to.
So that's explain that a little bit more. Explain
Well,
that
if
a
you're an
little bit.
independent contractor, you can be then protected under the Family First Coronavirus Response Act, and you can also be eligible for unemployment benefits under, in Illinois by the Illinois Department of Employment Security. So this is a different wrinkle and something very different from what we're normally used to, where 1099s, independent contractors, none of these laws generally apply to them. But in this case, right now, under the Family First Act, it does.
So under the HIPAA regulations now, how is that impacting what employers need to be aware of?
Well, again, you can't go too deep into discussion or into inquiry on employee conditions. So generally speaking, and this also relates to the Americans with Disabilities Act and other other medical or leave statutes. So in general, you can make general inquiries about their health or really their ability to perform the essential functions of the job. And the essential functions of the job is usually defined by the job description itself. So you have a valid job description, and then you make inquiries based on that job description, what the employee can or cannot do relative to that job description.
Okay, sounds good. Folks, let me again reintroduce our guest today. His name is Chuck Krugel. Chuck is a management side employment law attorney with a bachelor's degree in psychology from Bradley and a master's degree in psychology and a Juris Doctorate also. Wonderful person. He is
Juris Doctorate, not Juris Doctorate.
Juris Doctorate, yeah, I mean JD. JD, so I could, I could refer to him legally as Dr. Chuck Krugel also.
Yeah, that's
but,
right.
what we are discussing today should not be construed as legal advice either from Chuck or from the Center for Strategic Solutions. I'm Mohammed Faheem. I'm the CEO for the Center of Strategic Solutions, and you can learn more about us on our website, which is cfss.us. So if you need any specific legal advice, you can reach out to me and I can refer you to Chuck, or you could go directly to Chuck and get more information about specific cases. So things that we are discussing today is more an informational session rather than legal guidance. And we are talking about the impact of COVID-19 on employers and also on job seekers and employees also. What you need to be aware of as an employee. If you have any questions later on, I mean, you're always welcome to get into the chat box and send your questions via chat. We're not going to be, activating your video, your audio, and you can always, get your videos on so that we can see who is attending today. So quickly, in a nutshell, let us recap the FCCCRA and all of this alphabet soup really gets to me, Chuck.
Yeah, I know. Hey,
okay.
Hey, here's one for you.
Okay.
This is like mandated reporting for in Illinois. So this is the service that we use in Illinois. It's part of the CDC, Centers for Disease Control.
Okay.
Integrated Surveillance Information Systems. It's part of the, and then there's a part of this called the National Notifiable Diseases Surveillance System.
Oh boy.
And NEDSS. So these are all part of the Centers for Disease Control. And then Illinois all 50 states subscribe to this. So in Illinois, it's called the Illinois National Electronic Disease Surveillance System. How ominous is that sounding is that? So,
okay.
I mean, this is in Illinois.
It sounds so ominous, though. Okay, surveillance system. I mean, come on, Chuck. What are we getting into over here?
It's Orwellian. Yeah, it's This is so like if you're an employer and you're in certain industries like anything involving healthcare, education, anything with children, where you may be called what's called the legalese or quote unquote mandated reporter.
Okay.
That means you have to report issues of abuse or health issues involving certain individuals. If you're a mandated reporter, you have to report cases of COVID-19 to this National Electronic Disease Surveillance System. And, and it's all this alphabet soup, acronym soup about this stuff, but this is what we're doing now. And I haven't seen much guidance. I mean, there is CDC guidance on this, but I haven't seen much talk or use to this. So it's hard to say. I mean, they say all 50 states are subscribed to this, but yeah, I can imagine Illinois be compliant, but a state like Texas or, maybe Arizona would be hard to fathom them being compliant. But, we're assuming this is the way it's operating.
Well, I think that's a perfect segue into what I wanted to go into after this. So who's whose responsibility is it to report this? Is it the employer's responsibility, or is it the responsibility of the testing lab to report this? And and if it is the responsibility of either or, who should they be reporting to?
Well, first of all, the labs are going to be reported are going to be required to report anyway. They're legally
Okay.
mandated. So anytime they get positive tests, they're supposed to record that into the CDC database, the ones we just mentioned.
So the employer
Employer,
does that, or the lab does that?
the lab will do that. The employer could be required. The employer reports too for any workplace-related occupational diseases, like with OSHA or with COVID-19 too. They're supposed to report if they're a mandated reporter. Now, if they're not a mandated reporter, they don't have to, the business doesn't have to report. So it's possible that the testing company, if they're using like a testing company, they could be required to report, but the employer may not.
Okay, let's talk a little bit about the, again, from the employer's point of view. Uh, Employer gets a report that Mr. X or Miss X is COVID positive.
Yeah.
What is the employer's responsibility of informing the rest of the staff in their setup? How do they do that? Uh, how does that work?
They don't necessarily have a responsibility to report it to the rest of their staff, but they should from a human resources management perspective, as opposed to a legal perspective. I would say, I would advise them to do that. I had a call a few months ago from a client of mine, a manufacturing client, and I told them to report. They're in the suburb. And I told them I think they had one or two infections, and I advised them to report it to their village hall because they might have to do contact tracing too and all that. So I think you're better off being transparent and telling your coworkers about this. Now, here's the key thing to me is not so much what to tell them, but how to deal with them about this, because obviously you don't want people running around,
Right.
in fear and this hysteria. And so you're going to have to kind of put a clamp on that, a lid on that, and tell people how to react, how to deal with one another. And if they're afraid, then don't come into work, take off leave time or something like that. And and basically continue monitoring, continue doing testing, temperature taking, whatever you've been doing in the workplace, or continue doing nothing, involved with testing or monitoring, but make sure that you contacted the if you've done any reporting, if you want to the CDC, or
Okay.
you make sure that the employee, that their health professional reports on their behalf.
Okay. Let's talk a little bit now about the importance of employee handbooks, especially in today's litigious world where we have attorneys like you on the management side, and then you got a lot of bottom feeders on the other side who want to sue, you know, businesses, just for lack of a better word. I use bottom feeders. You know that my son is an attorney,
Yeah.
so is my daughter-in-law, but they are not bottom feeders, okay? But yeah, there's a lot of people who are looking to see how they could go in and make some quick money, for lack of a better word, over there. So employee handbooks now, how important are those, and are they mandated for every size business?
It's not mandated for every size business unless you're like a government contractor, or there's some sort of law regulating you that requires it. But generally, as a general rule, it's not required. I advise employers only to put into their handbooks what they will actually follow. So
Okay.
if they only put in content that you intend to comply with as an employer, because frankly speaking, if I have to go before a judge or a jury, and we have to testify, or we have to explain to them that they have a handbook but they never followed it, that's going to look a lot worse than not having a handbook.
Okay.
So that's the general rule about it. Now, if you want, you could get as specific as you want to be. However, you have to also realize that it's impossible to put everything into a handbook in the same way that it's impossible to put everything into a legal contract. There's no such thing as everything from A to Z in these documents. So as long as you're prepared to have a few holes in it, and you could fill those in down the line, then you want to be as complete as you believe you need to be.
in a very short answer, Chuck,
Yeah.
you want to talk about some possible policies that employers need to have in the employee handbooks?
Yeah. So you're going to
Just a
want,
broad overview.
yeah. So you're going to want anything that relates to wages, hours, or conditions of employment. These are like the three topics. These are legal terms that are used in the National Labor Relations Act. So, and also the EOC uses these terms. So anything involving how much money they make, the benefits they get, how they're paid, when they're paid, anything involving the conditions of work that, safety, any rules or regulations and specific to their industry, the benefits they get, the hours they work, the hours that time off that they get, things like that. And then obviously for any pandemic related situations or health related situations, you want some sort of reporting mechanism to the employer so that they can report whether or not they can perform the essential functions of the job, and then how the employer might investigate whether or not it's a legitimate claim that they have regarding time off from work or the need to leave work.
Now, do these handbooks have to be physically printed available, or could they be online?
Both. It could
Both.
be either one. So I've created handbooks for employers that were only a few pages long. The intent was that the employee could, because this was these were restaurants or fast food type businesses, and basically I created them so that the employee can actually have them in their pocket, like and keep them in their back pocket or something while they're at work. And then I've done employee handbooks that are 100 pages long. So it really depends on the needs of the business and their industry. But it could be both online. If you're going to do an employee handbook and only have it online, then make sure that your employees can access it. Because if they
Okay.
can't, for whatever reasons, income or even language reasons, you may be held responsible for that as the employer.
Okay, sounds good. Folks, it's about 22 minutes into the conversation. Again, my guest today is Chuck Krugel, who is a management side employment law attorney practicing in Chicago for quite some time. Chuck and I have known each other uh, for a long time now, and he's one of the few attorneys who is actually allowed or invited to visit my home. So, okay, that tells you what kind of person Chuck is. But jokes aside, very knowledgeable, very informative. And if you have any questions at all about, employment law and what you need to know as an employer, or even as an employee, Chuck would be more than happy to guide you and assist you. Again, a quick disclaimer: what we are discussing today is not to be taken as legal advice, but more as an information. So Chuck, again, you have got a beautiful background in there, but man, I'm losing your face in there because
So let's see. Maybe if I get closer.
yeah. Now,
There it
now,
goes.
now you're looking good. Now
All
you're
right,
looking
thanks.
good. Okay. So coming back to the employer again, what would be your advice to somebody who's starting off a new business? Do they need to dot all the I's, cross all the T's before they launch a business, or can they work their way into coming up with all of these requirements?
I think you could work your way into it somewhat, because I think it's unfair to require a business owner, especially for a new business, to well, dot every I, cross every T in advance, especially when you're not sure. And honestly, there's a lot of unscrupulous attorneys and consultants and accountants out there who would try to take advantage of that too. So what I would do is focus on the licensing requirements of the business and your
Okay.
structure, getting license, getting your permits and things like that, and all in line, and then working on the employment related aspects of it. However, if you're going to hire, I mean, you're going to need to start saving all that information, the demographic or the data about applicants and who you're hiring from day one. And you're going to have to make reports like to the Illinois Department of Employment Security and all that, uh, from day one too.
Okay, let's come back to some of the employer agreements that employers enter into when they hire someone. Now, with these new rules and regulations coming into place, uh, are are there any requirements that those agreements have to be modified to reflect, the new rules?
Yeah, well, first of all, even before the new rules, I would have said that 75% of all employment agreements I see were unenforceable or had
Wow,
or had clauses, a significant number of clauses that were unenforceable.
75%, Chuck?
And that was before the changes. So now we have these
Holy.
new changes in the law that are basically making these agreements illegal to a large extent. So I would say now 90% or more, at least 90% of these agreements are unenforceable. It's a change that went into effect in the last year. So basically, it's you have these non-competition or these restrictions against non-competition agreements, confidentiality, that type of stuff. So I would, as an employer, I would only implement those on an absolutely necessary basis. And when I say absolutely necessary, I'm not talking about like you have anecdotal evidence to support that you need this. I mean, you have real evidence, quantifiable or whatever, or qualitative evidence that is going to support your need to have these types of agreements.
Wow, that is scary.
It's an
90%.
exhaustive analytical process. And I can tell you
Okay.
one thing: if you're an employer and you're looking for a quick way to go about this, there's no such thing. So if you're looking for a quick way to implement an agreement or get an employment agreement, you basically have to go in with the thought that it's not going to be enforceable, and I don't care if it's enforceable or not. It's basically just say you want to put your employees on notice that we're watching you.
Oh boy, that is scary. From an employer's perspective, folks, again, be aware that the agreements that you have in place. Definitely, I would like to advise you to have someone, an attorney, preferably look at them and see if they can be updated.
Or if you can't
And
afford the attorney, then just get rid of them.
yeah, okay, that okay,
If you can't afford the legal analysis to find out if they're correct, then you're probably better off without the agreement.
okay.
As
Now,
long as you understand it's unenforceable too, or yeah, I mean if you decide to
so
stick
can you
with
can
it.
you can you can you quick give me some quick examples of what could be unenforceable? I know about the non-compete things. I mean, those have forever. There's been challenges to the non-compete agreements.
So, all right, not looking at the non-compete, but like a confidentiality agreement. So let's say you come into contact with the employer's clients and you make small talk with them, you know them, maybe they've invited you to personal stuff and you go off and start your own business and now you want to bring that client, the one you've established a personal relationship to you. So it's possible that the employer can restrict that with a valid agreement, but more likely than not, if the terms, like for example, if they create a blanket statement that you cannot pilfer or poach any of our clients, that is probably not enforceable.
Okay.
If you make a statement saying you cannot poach client X, Y, and Z, and specifically state why, then you have a higher degree of enforceability, a higher probability of enforceability. A lot of it has to do with specificity and the narrowness of the clause itself. I mean, the one that always comes up is in the non-compete part where it says like you can't compete against us for 1 year or
Right.
like across the country.
Right. And
Now those are
it has to have a specific time bound and a geographic area, right?
And usually I would say 6 months is like the most, unless you could come up with a really compelling reason why not to why they have more than 6 months. But generally speaking, I would say that 6 months is the most. And then maybe if you're a local employer, like in Cook County, then you would want to restrict it to geographic limitations to Cook County, or at the most, maybe the state of Illinois.
Okay. So discussions between the employer and the employee, are they protected by any chance? I'm thinking of the room where it happened. Just that it's
Yeah,
just coming out now. Okay. But jokes aside, again, I mean, is there anything like that that the employer can hold on to? It's like, hey, I never meant to say this to this guy, and now he's going around saying that I said this.
that you mean from, well, yeah, the employer, any health related information is generally protected information, or anything about, well, health related, family, medical stuff. So yeah, information related to the employee and health information related to the employee's family or their dependents is generally protected. So an employer cannot just go, be a loudmouth about that type of stuff.
Okay,
Also
sounds
the
good.
employees
Yep.
too. I mean, the employees are restricted in that regard also.
Okay, it's about 30 minutes into the conversation, folks, and we'll be finishing off in a few minutes. I mean, we can go on and on forever, but I know that it's a working day today. A lot of you are taking time off to join the discussion. This would be available later on, and we'll be posting this on YouTube also, so you can go back and refer to it. Uh, let's recap in what we have discussed today so far. So, importance of employer handbooks, importance of keeping them updated to reflect the current rules and regulations, uh, the obligations that an employer has or does not have to report this COVID-19 positive cases to any governmental agencies, and also to their staff that is there. And basically at this point, too many alphabet soups are coming in, and some of the things that you told me about the agencies that this has to be reported to oversight or surveillance,
Yeah,
those are scary words, Chuck.
yeah, I know. It's bizarre. These were I don't think that they were intended to be ominous. I just think these were created kind of haphazardly. A lot of these laws or a lot of these regulations and laws regarding the pandemic were written haphazardly. So this is why the effectiveness of it, or I mean, why the dates of effect that they went into effect were put off, and why enforcement's has been put off too. So there's so much of this going on right now. It's hard. Attorneys, I mean, we're having a tough time keeping track of all this.
Absolutely, absolutely. And that's what I keep hearing from my employer clients also, and my friends in the legal community. I've got more friends in the legal community, Chuck. So be aware of that. Okay.
Yeah.
But any other questions that you have, folks? If you just want to go ahead and get into the chat box, if you have questions, we'll be happy to take those. If not, you always have my email, and I'm going to put that in the chat box
Here's
so
a
that
question.
you
So
can. Yeah, go ahead, Chuck.
if an employee returns back after recovering from COVID-19, does the employer have the right to ask for a doctor's note if the employee can return to work again? Yeah, you can. I mean, basically, you can ask. I what I would ask for is if they're able to perform the essential functions of their job. That's like the politically correct way of being in line with these the Family First Coronavirus Act and the Americans with Disabilities Act. So basically, are you able to perform the essential functions of the job? And if they, you can require a doctor's note. If you want, you can send the doctor or with the employee, give them a copy of the job description and have them, go off everything they can or can't do within that job description. That might be the best way of doing it, or sort of best practice, as opposed to just, asking them or telling them to just get me a doctor's note. Um, Asking specifically for a doctor's note, though, under under these new laws involving the pandemic, you can get a note from a medical professional, not just a doctor. So in the past, under some of these other laws, like the ADA, you're allowed to or permitted to ask for a doctor's note, but under this new statute, you can only ask for like you're not required just to go with a doctor, but you could take like a physician assistant, medical assistant, a psychiatrist, psychologist, whatever.
Okay. So, folks, again, please be aware that the rules are changing almost on a
Constantly.
day-to-day
Yeah.
basis. Uh, there is no real clarity at this point, is the best way that I can put it, as to what the obligations are and what are the implications of not following these things. Also,
There's no
uh,
single source for information
there's no
too.
single source. There's no
Yeah.
single source, and that's what when I reached out to you first, I had asked the same question. Who's responsible for reporting? Who does they report to? What happens if they don't report? You know, at this point, if you have any questions, anything that you feel that you need to know, feel free to send an email out to me, and I will reach out to the right resources to get you some answers. And I have put my email in the chat box, and we will be finishing off in the next 5 minutes. Again, in the interest of keeping it short and to the point. Just don't want to go on and on and on. Chuck and I have been talking about different aspects of the unemployment requirements and employment filing and others in the previous webinars that we have done. Chuck, you want to quickly update us as to what is happening on that aspect now? Again,
Unemployment.
unemployment IDE is under the scanner. I keep on hearing,
There's lawsuits being filed against them. I just saw it in the paper today that there's you talk about these like bottom feeding attorneys. There's attorneys out there now who
yeah,
are suing and filing they're going to file class action lawsuits against the state
yes,
for their unemployment comp administration.
I heard that yesterday also, as the challenges that the system is facing. The system was not set up to address these kind of issues, Chuck. I mean, I worked with Illinois WorkNet for a long time, you know that, and you know the system just was not set up to deal with the volume of claims that are coming in. 1.5 million, come on. Even if you hire 300 new people, by the time you train those people to address those issues, the laws are changing again, and the numbers are going crazy up and down. You know that the unemployment numbers that are reported are not the correct numbers.
Yeah.
Okay. I have written a huge article on this as to how those unemployment numbers are calculated. I mean, uh, that is the most screwed up thing that I have seen in my life, is to come up with the unemployment numbers. 10%, 3%, 4%. The systems, uh, that whole system is messed up, folks. So don't believe those unemployment numbers that you read or see on a monthly basis. They just take 60,000 households on at random across the country and ask them some dumb questions to come up with the unemployment number. With that, any more webinars on EIP? Those who did not receive, what is that? Chuck, you want to address that? If
I don't know what the EIP is.
Okay, you want to, Fozia, you want to go ahead and tell us what you mean by EIP? We'll wait to hear from Fozia, and if not, we will address that again.
Oh, by the way, there was a question, and for some reason I was only able to send an answer privately, but somebody asked, you mentioned changing laws frequently, please list resources we can refer to. And the U.S. Department of Labor, they've put out a lot of really good material on this and pandemic. I think they're like, from the employer standpoint or workplace standpoint, they're probably the best I've seen so far.
Okay.
And then the Centers for Disease Control, and in terms of the biological or the actual medical info.
So what I could do here, Chuck, is if you can send me a list of those resources, I'll post that on our website, the cfss.us website. And obviously, I'm pretty sure that we'll give a link to your blog also, and you keep that updated all the time. I've seen that.
Yeah.
So let's end up for the day today. It's about 38 minutes into the conversation. Again, thank you so much. Guest today has been Chuck Krugel, management side employment law attorney, very informative, very knowledgeable, very giving person. And Chuck, thank you so
by the way,
much
just
for your
I guess
time.
Real quickly, somebody did ask about. All right, so
Sure,
the
go ahead.
stimulus checks is what I think they were talking about. EIP.
Oh yeah.
You have to, for whatever, you have to keep applying for that. I'm assuming, if you haven't received it yet. And then I don't think there's any way to call them on the phone. So my understanding is you have to go into, there's a database that you fill out, that you sign up for, and then they're supposed to get you the stimulus money.
The IRS website has a link to this that you can go and register, even if you're not filing for taxes.
I can hear you.
And you can definitely get more information on that. We are not going to be addressing that over here today. Just a quick update on the additional unemployment compensation that was coming in from the federal government, the $600. I believe that is going to be ending in July. Have you heard anything, Chuck, about that being extended?
They're talking about it. So it's my guess is yes, they will extend it, because frankly, I think it's political. So this is, I think Trump needs to keep this going. So my guess is they'll extend it.
Okay, sounds good. And with that, thank you all very much for joining us today. Again, my name is Mohammed Faheem. I'm the CEO for the Center for Strategic Solutions, and we try to bring you, information that is needed on and off. It's not on a regular basis, but if you have anything that you need to be, need to know more about, feel free to send me an email, and I will reach out to the right resources. Our guest today has been Chuck Krugel, management side employment law attorney, a lifelong Chicagoan, and a great person and a good friend.
Thanks,
Thank you,
Mohammed.
everyone. Thank you, Chuck.
Thank you. Take care, everybody.